Hi, everyone. Thank you for joining us today. I'm LauraLee Lawley. I'm a partner at McGuireWoods in our healthcare group. I am out of our Charlotte, North Carolina office, and am one of many of our attorneys throughout the firm that deal with and lead dental practice transactions and formation of dental service organizations quite frequently. I am here today with my colleague, Justin Knapp, who is also out of our Charlotte, North Carolina office. And Justin, I'll let you say a few words about yourself, and then we'll get going. We have a lot that we'd like to cover today.
Thanks, LauraLee. As LauraLee said, I'm Justin Knapp. I'm also with her in our Charlotte, North Carolina office, and also assist with these dental practice transactions. Appreciate everyone joining today and looking forward to this presentation. Thanks.
Thanks, Justin. And so here we have the topics that we would love to cover today. We've only got an hour together, and there's a lot of ground to cover. So hopefully we'll be able to touch on each of these things, and if not, or if you'd like to do a deeper dive into any of these topics, Justin and I and others at McGuireWoods are always happy to chat about any of these things and what you all are seeing in the market and otherwise. And so if you look at this slide, we're going to cover legal structuring, common structures for dental practice transactions, some legal due diligence issues that we come across frequently, but certainly not all of them, negotiation and key transaction documents, the common things we see in negotiating transaction documents in these types of deals. And then if we have time, Justin's going to touch on a few regulatory compliance issues that can be fairly common with dental practices and DSOs. So first I wanted to talk about pre-transaction strategy and transaction process. It can be quite a lengthy process depending on the nature and size of transaction, and depends on a number of factors how long a transaction might take. The more you can do, if you're a practice owner or a DSO owner looking to go to market, the more you can do prior to the transaction, the smoother and quicker the transaction is likely to go. But I think generally speaking, one can expect the entire process to last from 3 to 6 months. Or sometimes we see deals go much quicker than that for various reasons, and sometimes they're drawn out a little bit longer than that. So I mentioned your pre-transaction strategy. One thing that we recommend thinking about is if you're going to market to sell your practice or your DSO, is some self-diligence and some housekeeping. So work with your current advisors and introspectively look at your legal structure, your accounting, your agreements, and really making sure everything is organized and the way one would expect it to be, not necessarily saying things would necessarily need to be restructured, but sometimes that is the conclusion after working with legal and tax advisors, that it would be best to restructure before going to market to make an organization more attractive to buyers, but that's not always necessary. But really getting your house in order can really save a lot of time in the transaction because, like we'll talk about later with diligence, it can be quite a heavy lift. So the more organized you are and the more you clean up things that should be and can be cleaned up, like getting signed contracts together and making sure you have policies and procedures in place, et cetera, the smoother the diligence process can go in the transaction. So once you're ready to go to market, First, think about which advisors you need to engage or want to engage and when. It's not always necessary to get everybody engaged at the same time, but frequently sellers will engage an investment banker. It really depends on the size and nature of the transaction. Definitely accounting and tax advisors. And I certainly think this is the one advisor that you need to consult with early and often because the tax structure and the tax consequences of a transaction are obviously really important to your bottom line and really easy to trip up. So that's a plug for our CPA and tax advisor friends. They are key to having a transaction go smoothly. And then, of course, legal advisors. Some people will engage an attorney to help them earlier on in the process, and some will wait a little later. Just depends on preference. And again, size and nature of transaction governs a lot of this. When you go to market for larger transactions, we'll see a confidential information memorandum be circulated to prospective purchasers, and this is usually put together by bankers or other advisors, and explains the company and what they're about and what their plans are and what kind of funding they're looking for. Are they looking to sell, or are they looking for debt, or some combination of the two? But it's really the book about seller and all the information a buyer would initially want to know to make a decision and submit an LOI. And so next, we would typically see a letter of intent. This document, I'm sure you all are familiar, lays out the key terms of the transaction. They are typically non-binding, which means it's not a guarantee that a deal will go through on those terms, but serves more as a roadmap for the transaction documents that are eventually negotiated. And you will often see an exclusivity provision in the letter of intent, which binds seller for a limited period of time, usually 60 to 120 days, to this buyer. And that's really typical in our experience, and that will be one binding term of the letter of intent. And it's really a nod towards the fact that the buyer, once they decide to enter into a letter of intent, they are going to earnestly begin their diligence and expend a lot of time and resources. And so they don't want their seller going out and shopping the practice or the DSO once they start doing that. Then you hit the due diligence phase. This can consist of financial due diligence, quality of earnings, legal due diligence, and compliance due diligence, and that is an ongoing process. It'll usually start with QAV and financial so that the buyer can come up with a reasonable purchase price and multiple, but it will be ongoing and quite a heavy lift for a seller for most of the transaction. Then the next step is usually negotiating the key transaction documents. This can consist of purchase agreements, the DSO structural documents like the administrative services agreement and ancillary agreements, dentist employment agreements, etc. And then, of course, closing. We also see a lot of activity in forming DSOs without an underlying transaction, which is just like it sounds, a group of practices or somebody with multiple locations or other reasons, which we'll get to shortly about why it could be wise to have a DSO, really want to get their organization set up as a DSO prior to selling. So that's something that we often see and assist with as well without an underlying transaction going on. The reasons to form a DSO. We often have people call us and chat with us and, have heard about DSOs and think they need one. And often forming a DSO would be wise for various reasons, but sometimes it's not necessary and may not make a lot of sense. One thing I tell clients often is your dental practice does not have to be in a DSO structure to sell to private equity or a existing platform or another buyer. That is usually not a prerequisite, although in certain circumstances it might make sense. And so some reasons are on this slide of why you might consider forming a DSO absent a sale, and that would be scalable processes and efficiencies of scale, things such as HR, IT, purchasing, payer contracting. Sometimes it makes sense to congregate everything under a DSO for those efficiencies. Professional business management, of course, this lets dentists practice dentistry and lets the professionals run the practice. So that's another reason. Non-dentist ownership of a DSO. The most obvious reason to form a DSO is corporate practice of dentistry restrictions. And in several states, as I'm sure you all know, a non-dentist may not own in a dental practice. So setting up a DSO compliant with state laws is one way where you can have a non-dentist owner of the DSO who profits off the management fee collected by the DSO for the services it provides, but they cannot directly own the practice. If you're expanding within your state or certainly into multiple states, it often makes sense to have a DSO. And then another consideration is segregation of historical liabilities. And here what I mean is sometimes you will have separate practice entities for different locations, either because of organic growth or otherwise, or even separate what we call sub-DSOs, where there is if it is a multiple state operation, you sometimes see separate DSO entities for different states or different regions, just depending on a number of factors. So like I said before, we often have people call us thinking they need a DSO, and frankly, they don't need a DSO, or it's not worth the resources to set up a DSO. Again, it's not a prerequisite to sell your practice or your practices. So forming a DSO, just for the sake of having a DSO, does not really create any extra value. Again, a buyer is accustomed to buying dental practices, even multi-location dental practices, without an existing DSO. They will either have their own DSO that they want to roll you up into, or be starting a new platform, either in a state or a region or their initial platform. There are some front-loaded costs with it. Accounting, operational costs of congregating everything together, legal costs of getting compliant documents in place. So while it's likely not as expensive as a transaction, a full transaction or sale, it can have some costs to it that you need to consider whether it's worth it. It can also add additional structural complexity, educating the owners on how a DSO works operationally and getting those structures into place. Employee benefits is really important to make sure you are offering benefits out of the correct entity and the employees sit in the correct place to offer those benefits or under the correct organizational umbrella, so that you don't trip up any negative ERISA consequences. And there are experts that look at that all the time. So something to keep on your radar and get proper advice on that. And then in some circumstances, it could actually decrease your flexibility for future reorganization. One example of this is having to move assets back and forth between entities. Another cost is maintenance costs. The more entities you have and the more complex your structure, the more costs you're going to have associated with accounting, tax, corporate maintenance, filings that have to be made with the state or local governments. So another thing to keep in mind. And then corporate practice of dentistry limitations. Of course, there are a handful of states that will allow direct ownership by non-dentists in a practice, but those are fairly limited. still come with some restrictions on who can and cannot make clinical decisions. That is, always in the hands of the dentist. And then there's, of course, what we're talking about here today, which is fairly common, especially in your corporate practice of dentistry states, and that's the PC MSO arrangement, where we'll get into more detail and have some pictorials and a couple of slides, but this is where you have your dentist, of course, or dentists owning the professional corporation, or PLLC, and then that PC has a management agreement or an administrative services agreement with the DSO, and the DSO charges a management fee. We'll talk about fee structures as well in this presentation, but the management company charges a management fee for the services it is providing to the practice, the non-clinical services. So as I mentioned, the structure of the entity in the DSO arrangement is driven by the state corporate practice of dentistry restrictions. There are a few things on this slide, the key things to consider and work with your professional advisors on, someone who's well-versed in this space, because the nuances can be many. But licensure of professionals. One question you need to be asking, especially if you're crossing state lines, is does your dentist owner need to be licensed in the state in which the practice is operating, or are you permitted in some circumstances to use a dentist that is licensed perhaps in another state, as long as they're not, of course, seeing patients? That is one question, and it varies by state. This goes to the ownership restrictions. Who can own your DSO? Often it's only dentists. Sometimes a certain percentage can be owned by non-dentists as long as they're not controlling clinical decisions. So that is another thing that needs to be considered. Fee splitting laws, this varies by state as well, and this governs whether a dentist can split their professional fees with a non-dentist, and depending on the language of the statute, whether it triggers fee splitting laws when considering your management fee structure. Active practice requirements. This is something we're seeing more and more pop up in states or in official guidance or commentary from the states, and it's largely arisen out of the fact that many DSOs are using what we call a nominee owner that may not actually be practicing in this particular practice or location because of geography or other considerations. So they're using their friendly dentist to own in multiple states, and the question arises about how involved they are. So there are a handful of states that have very specific active practice requirements that, say a dentist, that owner must practice at a particular location for a particular percentage of his or her time. And sometimes they're not that specific. It's a little more gray, and you have to consider all the facts and circumstances as to whether you're meeting that particular guidance. I often also tell people the conservative approach is to always have somebody own your practice who is at least somewhat active in the operations, even if as a clinical director and not necessarily seeing patients in that location, because it helps with the corporate practice of dentistry analysis, much more so than having a true nominee owner who's not involved at all. And then lastly, state fraud and abuse laws, looking at, and Justin's going to get into this in more detail, but really thinking about referral patterns, whether other specialties are involved. Do you have orthodontists employed or in the ownership mix as well, and how are they referring, and does that trigger any state fraud and abuse laws? The dentist compensation, are they getting paid on a productivity basis? Are there any designated health services being billed? How are they getting compensated for those? And then finally, like I mentioned, just your general DSO fee structure and making sure that the way the fee is structured is compliant with state law. So basic DSO structures. There's a few listed here on this slide. The DSO, like I mentioned, owned by an investor, does not need to be a dentist. PC usually has to be owned by all licensed dentists. Your connection between the non-dentist investor and the practice is through your management services agreement. If there is an acquisition, it can really either be a stock purchase or an asset purchase. And we'll talk a little bit more about that in just a moment. And then, of course, there's DSO lending and transaction lending, and the considerations you need to think through on those types of transactions, whether with or without an acquisition. So basic DSO structure. This is what I've been talking about for the past few minutes, but here it is in a picture. You got your non-dentist investor on the left owning the DSO. You've got your dentist owner on the right owning your practice, and then the administrative services agreement, or also called a management services agreement in some instances, being the link and governing the fee being paid over to the DSO. We can talk a little bit about the fee right now while we've got this picture up here. There are different variations on the fee, and it's largely going to be governed about how strict corporate practice is in your particular state. The most conservative is almost always a flat fixed fee, or we also sometimes see a cost plus fee where you take the, like it says, you take the cost of the service or services being provided and apply a reasonable markup profit for the DSO. And then, of course, there's your percentage-based management fee where the DSO takes a percentage of profits of the practice. And this, of course, is more desirable and more closely replicates ownership of the practice, but also carries more risk with it in many states. And many states will outright prohibit it. North Carolina is one of those states, as many of you might know. You cannot do a percentage-based fee in North Carolina. New York also generally prohibits it. So very important to look at state law when structuring your management fee and making sure you're in line with that. So next slide, talking about acquisition structures. Stock purchase is one option. This, of course, is where the stock is sold to an acquiring practice or another dental owner of an acquiring practice. You need to look at, with your advisors, whether state law allows a practice to own another practice. Many states prohibit that, and the statute says that only individual licensees can own a practice. And it may be different depending on the form of entity. It's much more common for that to be a restriction in professional corporations than it is in limited liability companies, but it can apply to both. So important nuance to pay attention to in structuring your transaction. And of course, in the stock deal, your legal entity at the practice level remains the same entity. So this may be desirable if this is the initial DSO acquisition, the initial platform acquisition, and you want to use that selling dentist as your practice owner going forward. It's also desirable if there are payer contracts or other material contracts or licenses that you don't want to disturb, and if by keeping them in the same entity prevents you from triggering change of ownership requirements that may require a new license or a new contract, or at the very least delay your transaction while you wait for a third party's consent, then a stock transaction structure may be more desirable. The next structure, of course, is an asset purchase, and this is where the acquiring practice entity acquires the clinical assets, and state law will dictate what's clinical and non-clinical, and your DSO acquires the non-clinical assets. Here, this may be desirable if there are significant liabilities at the old practice that you want to leave behind, and by starting a new practice, you are able to more cleanly leave those behind. It's also desirable if it's what I call an add-on deal. So if the DSO already has a platform established and it's acquiring other practices, or bringing other practices under its umbrella, and the existing main practice already has good payer contracts and licenses and permits and employees, and can just take the clinical assets of the old PC fairly cleanly. So that is often a desirable ownership structure. This slide shows DSO lending structures. The lenders often seek to have the DSO and the practice as co-borrowers. They often also require guarantees of either or both for the individual owners, but not always. Depends on the loan package, of course. You've really got to make sure that you're working through state corporate practice of dentistry considerations, because they could pick up either directly or indirectly often the terms of the loan, especially how intertwined the lender wants the DSO and the practice entity to be, for example, through guarantees of the dentist or the practice. And lenders who work in this space a lot, not just dental, but medicine, veterinary, anything where you have or are required to have an MSO structure, are typically usually pretty familiar with the pressure points there. You also need to be aware of anti-assignment rules and what we call the double lockbox structure. And we could talk about this for a long time, but we won't bore you with that, but just suffice it to say that this is usually triggered when a practice takes government receivables. So in a dental practice, that's usually Medicaid. Sometimes there's others like TRICARE, but what it says is a lender or third party cannot really take a security interest directly in government receivables. So the way that the industry gets comfortable is by setting up a double lockbox structure where they get swept into a separate account. And then something that's not on here, but that you'll see in lender transactions, is what we call the collateral assignment of the DSO document. So often the lender will want to take collateral assignment of the administrative services agreement, for example, and that's because the DSO often has a security interest on certain of the practice's assets through there. So just another deal point to keep in mind that you would likely see. So I think I've touched on most everything on this slide, but just kind of sum it all up, some things you should be considering when determining a structure, hopefully involving your tax and other advisors early on to make sure you don't inadvertently trip something that will have negative consequences, especially tax consequences down the road. But are the contracts assignable? If you're doing an asset deal, you want those to be cleanly assignable, and you don't want third-party consents to delay your deal significantly. Does the acquirer, the buyer, need the target's licenses, permits, provider numbers? If so, you may want to do a stock deal so you can keep all those in place. If there's significant liabilities of the target you want to shed, then an asset deal might be more desirable. Do any assets need to be retained or spun out? Who owns your assets? Does the seller, the dentist seller, own some of the assets just because that's the way the business grew? You know, it started out small, grew pretty big. Maybe initially he or she owned some of the equipment directly. So identifying where the assets fit and making sure they get to the right spot. And then how established is the acquiring practice entity? Again, if it already has profitable payer contracts, licenses, permits, employee benefits, you may want to just use that existing practice to acquire the clinical assets of the target and keep everything a little more smooth. Now I'm going to turn it over to Justin. He's going to talk a little bit about diligence issues that we often see.
Thank you, LauraLee. So we're going to start off with operational diligence issues. And first, you, as LauraLee mentioned, want to figure out early on where collateral assets are located you may want to consider are any of the assets held by the dentist owners, affiliated entities that need to be assigned or transferred to the practice or DSO at or prior to the closing. That's one consideration. You also want to consider whether there are any liens that need to be released in connection with the transaction. As for non-competes, you want to determine whether they have non-competes in place and have your legal counsel to determine whether or not they're in compliance with state laws, especially for associate positions where it may be difficult or not ideal to enter into new arrangements prior to closing. With regard to billing and coding compliance, you want to diligence whether or not they've had billing and coding audits, when the last one was, ask them questions whether there are any issues or did they incorporate any of the suggestions, whether the audit was an internal audit or a third-party audit. So those are the sorts of questions you want to be asking related to billing and coding compliance. With regard to commercial and government provider arrangements, you want to review those closely to ensure that the target is in compliance. You also may want to consider whose name the contract is in, as it is sometimes there may be a contract with an individual dentist, and depending on the transaction, if he or she, the dentist, leaves, there may be an issue that you no longer have that contract. So that's important to look out for. As we're going to discuss later, there are issues that you want to pay attention to with regard to relationships with referral sources and fraud and abuse compliance that you're going to want to look out for early on. As for patient consents, you're going to want to diligence what process the target has in place, especially as pertains to anesthesia and minors, as this is a highly regulated space, and you're going to want to just make sure that the target has good processes in place and is in compliance with all the relevant regulations. So next, I think I might have advanced. Next, we're going to talk about structuring diligence issues. So we're going to talk about assets and collateral locations. Oftentimes, hard assets are going to be owned by the DSO, and non-professionals should also be employed by the DSO. Licenses and billing arrangements should be held by the practice entity, as should the clinical assets and dental records. The collections generally will be run through the practice. Another thing you want to consider is whether the DSO can employ dental hygienists and assistants. It's often required under state law to have the practice entity employ, or in general, we recommend that best practice is to have the dental hygienists and assistants be employed by the practice entity. So that's something that you're going to want to look out for. As for restrictions on professionals, you want to consider what state regulations are regarding non-compete and non-solicitation provisions. For example, what is and is not enforceable. Maybe the non-solicit provision contains a liquidated damage provision, and you want to look as to what the state guidance is and get counsel involved early to make sure that those are compliant. With regard to payer contracts, we recommend that you look early on whether or not payer contracts contain notice or consent requirements, as some may require notice to the payer as far as 120 days out, and you don't want that to delay the transaction at all. You also want to look closely at the contract to determine whether it's favorable to the entity and whether or not it's something you want to consider keeping going forward. Next issue is the administrative services agreement, and this is a big part of any DSO transaction. So first you want to consider what is the term of the ASA. Is it a fixed term or does it evergreen, which means basically does the agreement continue until it's terminated by either party? That's something you want to consider. You're going to want to pay close attention to the administrative services fee and how it's structured. For example, certain states may prohibit basing a fee off of the dental practice's income. You're going to want to pay close attention to that. In the event that the fee is based on a percentage or tied to the dental practice's income, we highly recommend getting a third-party fair market value opinion to make sure that that fee is within fair market value. You should also get your counsel involved early on to confirm that the DSO is handling the proper non-clinical responsibilities under the state corporate practice of dentistry regime, and make sure that they're not handling things that should otherwise be handled by the practice entity. These sorts of things can be procurement of equipment and supplies, negotiating leases, controlling bank accounts, as well as marketing practices. And these are all things that you're going to want to look closely at when you're reviewing the ASA, and just make sure that they're handled by the proper party, because having the DSO handle these things can increase risk on the state's corporate practice of dentistry regime. So that's just something you're going to want to look out for. With regard to dental board licensure and exclusion, you're going to want to diligence this and determine whether or not there are any ongoing risks from past board actions, whether they relate to the practice entity itself or individual providers. You want to ask the practice entity how often they conduct exclusion checks and provide the history of their exclusion checks and the results of those exclusion checks. You should also have your legal counsel conduct exclusion checks of their own, just to determine whether or not there are any issues, so that you can tackle them early on and get out in front of this. With regard to Medicaid participation, we recommend that you check the state Medicaid regulations and contracts, as states often have very specific rules on treatment. For example, some states say that you can only have x-rays once per year, absent specific medical necessity. You also want to make sure that hygienists are properly credentialed with payers, if that is necessary, and not automatically billing their fees to the dentist if it's not appropriate. So that's something you're going to want to look out for. These are more specific diligence issues that you may want to look into. One of them is OSHA. So you want to make sure that the target has a proper bloodborne pathogen exposure and hazard communication program in place, whether or not they have proper training protocols, vaccinations, and how they handle these issues in terms of gloves and having PPE. You also want to look into referral sources and staff turnover to get the lay of the land there, as referral sources may relate to certain issues related to fraud and abuse compliance. Another hot button issue right now is the COVID-19 issues. You're going to want to inquire early on as to whether the target has taken any PPP loans or provider relief funds, as it will likely require some sort of consent from the lender, as well as potentially the SBA. So that's something that you're going to want to get out in front of. You should also pay attention to local SBA guidance, not local SBA guidance, just recent SBA guidance, because you're going to want to determine whether or not there's anything recent that impacts your transaction. For example, recent SBA guidance states that in order to obtain PPP loan forgiveness, you need to have an escrow account controlled by the PPP lender. So this guidance is constantly changing and evolving, which is something that you're going to want to pay attention to. And in general, we just recommend starting the process early, as lenders are still working through these process issues and with the changing guidance. We also recommend diligencing whether the target has taken any COVID-19 measures such as telehealth, social distancing, furloughs, and whether or not they've changed their policy on elective procedures, because state guidance can vary on these topics, particularly elective procedures, and you want to make sure that the target entity is on top of this and is looking out for these sorts of things, and if they're not, that you can sort of get them in line with the transaction. Next, I'm going to turn it over to LauraLee to talk about the negotiation process and the key transaction documents.
Thanks, Justin. So I mentioned several of these before, so I'm not going to spend a ton of time on them and focus more on the items that I didn't do a deep dive into quite yet. And so we talked about the letter of intent and the term sheet as the first step and what that typically looks like, and exclusivity provisions. The core document for an acquisition is obviously the purchase agreement, either excuse me, either a stock purchase agreement or an asset purchase agreement. There will also be employment agreements. Often DSO buyers will want to enter into a new employment agreement with the owning dentist. Buyers differ on how they treat associate dentists who are not owners and who are staying on in the transaction. Typically, if their agreements look pretty good and there are not huge compliance problems with them, the buyers tend to lean towards keeping those in place at least until they're up for renewal and not disturbing them, because oftentimes you don't want your associate dentist involved in the negotiation process or delaying a deal. So that's what we often see there, but it varies. The services agreement, we talked about that in detail. That's your link between the PC and the DSO. And you need to consider things like the fee structure and what services the DSO can and cannot provide under the state corporate practice laws. There's also usually a space lease for the location or locations where the practice operates. Depending on state law, this lease may get assigned to the DSO, and then the DSO will sublease that to the practice. So you may have a sublease as well. And if the landlord is one of your dentists, then you need to consider the affiliate arrangement to make sure the lease is arm's length, third party, and complies with the anti-kickback statute, safe harbor, and any applicable state laws. For example, that the rent is fair market value and not a means to induce or reward referrals. You might have syndication agreements if your selling dentists are also going to acquire rollover equity in the DSO. These are their investment disclosure documents. The operating agreement for the DSO, if you're setting up a new DSO, you'll need an operating agreement laying out the governance for the entity. Practice, if it doesn't already have one in place or if it's deficient in some way, you'll want to make sure it has bylaws or shareholder agreement or a short operating agreement for a PLLC that fits with the other structural elements. The continuity planning agreement is an agreement between your dentist owner and the DSO, setting forth triggering events and events upon which the DSO can replace the owner of the practice. These are really important to consider under state law, and in some states, like North Carolina, I keep using them as an example, these are generally not permissible under the state corporate practice of dentistry rules. And then there are some states where folks get comfortable with them, but you need to be careful about what circumstances allow the DSO to replace the owner of the practice. So an important lever for the DSO, but also important to make sure it's compliant. Clinical director agreement. You may or may not have this, but this is the agreement if you do have one between your clinical director, dentist, and the DSO. And you may have a separate restrictive covenant agreement, or this could be built into the purchase agreement. It's really a buyer preference, but this will set forth the seller non-competes, non-solicitations, confidentiality, and also important to make sure it complies with state law and will be enforceable under state law. Certain states have specific guidance in case law and otherwise on how restrictive a non-compete can be, but generally speaking, the non-compete should really be crafted narrowly to protect the legitimate business interests of the company or the buyer. So if for example, if the practice kind of patient catchment area is truly only a 10-mile radius around the location, and the buyer, wants a non-compete that restricts competition for a 100-mile radius, that's not going to be enforceable in a lot of states because it won't be viewed as reasonable. So important to dig into those details to make sure the buyer is protected. And then, of course, if there's a loan element, you'll have a loan agreement, security interest agreement, and other typical loan documents, guarantees. So some of the key negotiation points, of course, purchase price is going to be super important. If the buyer does a quality of earnings analysis, that's really going to drive that. Subject to financial diligence, purchase price is often worked out in the early stages and subject to finding something material in diligence that affects the financial viability of the company, or a massive amount of debt that the buyer didn't know about, which would be unusual, or other material findings. That doesn't usually get materially adjusted, but it can. It just depends on what's found in diligence. But that sort of gets worked out early on. Also, rollover equity versus cash. Like I mentioned before, selling dentists may be offered rollover equity in the DSO, where they own a minority interest in the DSO company. It's not strictly required, but we do often see it, especially, of course, in private equity deals. And it's a good way to, have your dentist seller part of the organization going forward. It helps with culture and alignment of interest, but not necessarily required. I've mentioned this several times, but it's really important. Involve the CPAs early on so you can structure the transaction in a manner that's tax advantageous for both sides. One thing to determine really early on, whether you're the seller or the buyer, is whether the practice has made an S-Corp election, because that will lead to very specific structuring considerations that can usually be worked around, but the tax lawyers and the tax advisors need to know about it early so that it doesn't cause a delay later on. You need to think about governance rights and operational control decisions. If you're a DSO buyer or the DSO, are you going to give your dentist any governance rights at the DSO or the practice level? Of course, they've got to control clinical decisions, but if it's a larger organization, are you going to have some sort of clinical review committee or something similar to that? Again, not necessarily required, but might be a way to incentivize and align interests with your dentist partners. Employment compensation in terms, obviously something that's going to be near and dear to the hearts of your selling dentists as well as the associates. If their employment terms are going to change as part of the deal, you'll have in the employment agreement, state law permits restrictive covenants for both the sale of the business, which will be binding on your owners, often in the purchase agreement, or a separate restrictive covenant agreement, but then an employment restrictive covenant in the employment agreement. And here you need, again, to be careful what state law allows. I think most people are at least indirectly aware of California, and how there are very specific non-compete prohibitions on employees in California, and rare circumstances where you can do that. Other states have similar but maybe not as restrictive laws, so you need to be super aware of those. The indemnification package and the reps and warranties about the business, here's what protects the buyer and backs up the diligence that the buyer is doing. So it's very typical for sellers to have to make very extensive reps and warranties about the business, financial condition of the business, title to the assets, title to the shares, no material litigation, etc. And buyer will be indemnified for any breaches of those reps or anything that comes up post-closing that was on the seller's watch. And this is a risk allocation point and often heavily negotiated, who's responsible for what and in what amounts. And it depends on the leverage that the sellers have, as well as the size and the nature of the transaction. Always happy to talk to people and educate them on what we're seeing in the market, but it will vary depending on the size and the nature of the transaction. And then finally, whether there's going to be any escrow or holdback, this is largely going to be driven by diligence. For example, if there's material outstanding litigation matter that's not going to be settled or resolved until after closing, often buyers will want the seller to put aside a portion of the purchase price into a third-party escrow account to make sure that money is available to pay the claim when the time comes. And then, as Justin mentioned before, kind of new and still evolving are the PPP regulations and guidance coming out of the SBA. The most recent guidance has led us to using separate escrow agreements for the forgivable amount of the loan. And then in our last couple minutes, I'm going to turn it over to Justin, and he's going to go over a couple of regulatory compliance issues and challenges.
Thank you, LauraLee. So I'm just going to talk quickly about the differences between the federal anti-kickback statute and Stark. For starters, the federal anti-kickback statute is not a strict liability statute. You do not have to meet a safe harbor in order to comply. The best practice is to meet a safe harbor and structure your arrangement to meet a safe harbor, but again, it's not strict liability. If you do violate the federal anti-kickback statute, though, it does subject you to potential criminal liability. That's important to pay attention to. And we just advise getting counsel involved early to make sure the arrangements that are in place with the dental practice comply with the safe harbor or are otherwise low risk under the anti-kickback statute. Safe harbors tend to be quite specific. For example, as LauraLee was describing earlier, if you have a space lease and the landlord is a dentist owner, the space rental safe harbor requires that the lease is in writing, commercially reasonable, with your rate set in advance and within fair market value. So there's a lot to unpack there and a lot to make sure that you're in compliance with the safe harbor. And it's just best to get counsel involved to make sure that they're in compliance. Stark, on the other hand, is a strict liability statute. If you're in the Stark world, you have to make sure that you meet an exception to Stark or you will face civil liability. Stark prohibits referral of designated health services to an entity in which you have a financial interest. It is important to note that dentists are considered physicians for the purposes of Stark. However, it is also important to consider that very often the codes that are being billed by dentists are not considered DHS, but we recommend checking with the target entity to make sure that they're not billing codes that would be considered DHS. In particular, you may want to look out for certain things they're billing for, such as imaging, because that's where you tend to run into DHS in the dental space. In the event that you do violate the Stark Law, then you risk potential refunds. And outside of the federal anti-kickback statute in Stark, we also want to recommend that you pay close attention to state fraud and abuse laws, as they can sometimes track their federal counterparts, or they can be quite more expansive. For example, New Jersey has an all-payer kickback statute, which is more expensive than its federal counterpart, and you just want to make sure that you're paying attention to state fraud and abuse laws for that reason. So next, I know LauraLee mentioned corporate practice of dentistry and covered it in good bit, so in the interest of time, I'm just going to cover it kind of quickly. Generally, we just recommend that you get your counsel involved to make sure that they're tracking the state's corporate practice of dentistry requirements, and you want to also pay attention to active practice requirements that require the dentist to be actively involved. In general, the best practice is to have the dentist be actively involved in the operations rather than a pure straw man from a corporate practice of dentistry perspective. Sometimes it may be challenging to track down the state's corporate practice of dentistry regime, so you may have to look deeper at court cases, attorney general opinions, or even secondary sources for guidance. It's best just to get counsel involved in looking into that. Next, these are a couple additional issues that you may want to look into. You want to diligence the target's compliance program and its specific policies and procedures and how it treats compliance at HIPAA. How often is it doing HIPAA training? Does it do it on hire? Or does it do it annually? The extent of the training. You want to inquire whether or not the target entity stores any information offshore. You also want to ask whether there have been any past data breaches, any data privacy audits, and what have been the results, and what sort of procedures have they put in place as a result of those audits. With regard to marketing, you want to look out for specific coupons or discount programs that may present risk under fraud and abuse laws. You also want to look out for certain states have DBA requirements that you should pay attention to. For example, can you use the DSO name branding, or do you need to include the dentist name in any branding related to the practice? Some states also restrict marketing as it pertains to the corporate practice of dentistry. So the best practice is to give your practice the approval rights with regard to marketing, but also have your legal counsel make sure that all marketing programs are in compliance with board regulations, and in particular, regulations governing specialties, such as orthodontics or whatnot. And finally, basically just the main gist of this slide is that there are a handful of states that require DSOs to register with the Secretary of State, such as Texas. So in general, just you want to pay attention and look out for this issue and pay attention to the state regime to make sure you have all your registrations in place. So that is it. Thank you very much, everyone, for joining today. If you have any questions regarding the presentation or anything else, please feel free to reach out to LauraLee or myself. Our contact information is right here. So thank you again for attending, and have a great rest of your day.
Thanks, everybody.